In 1404, in what is now Germany, Marshal Wilhelm von Dornsberg had a legal dispute with an unfortunate fellow named Theodor Haschenacher. The dispute was to be settled not by words, but by combat. The two squared off with swords to fight to the death. Dornsberg's sword broke early in the fight. Not a great way to begin. But then he threw himself at his opponent, wrestled Haschenacher's sword away and killed him with his own sword, and thus the dispute was settled. Trial by combat took place in England too. In the 13th century, for instance, if a person was accused of a crime, they could elect to be tried by a jury, or they could wage a battle against their accuser. Trial by combat actually had a religious basis. Stories like the battle for Jericho when the Israelites blew horns and the walls fell down, or the battle between David and Goliath. These seem to show that God was ready to intercede in battles, and that a person who fought with justice on their side would prevail, regardless of their skill or weaponry. Needless to say, a little bit of skill and a decent weapon helped. And before too long, there were professional fighters who called themselves champions, who were available to fight for a fee. Initially, those champions were outlawed, so they pretended to be witnesses. One such witness, when he admitted that he was actually a professional fencing coach who'd been hired to win the combat for his client, was sentenced to have his hand and his foot cut off. I wonder if that's what they mean when they say going to court can cost you an arm and a leg. G'day everyone, my name's Anthony Marinac and welcome to Module 3 of our Introduction to Law. This module is all about the courts and cases, judges and judgments. In this first video, we'll learn about the courts and the court system in Australia, the United Kingdom and the United States. In the second video, we'll talk about how to research and cite case law, and then in the final video, we'll talk about how to read a case report effectively. The courts we'll be talking about in this video are all arranged in hierarchies. In other words, it's almost like courts have ranks, and the higher courts outrank the lower courts. So when you learn about a court, you need to be thinking not just about the court itself, but also about where it fits in the court hierarchy. So why do courts have hierarchies? Well, there are two key reasons. The first reason has to do with what we call the doctrine of precedent. You'll sometimes hear that referred to using the Latin term stare decisis. This is the idea that like cases should be treated alike. In other words, if two very similar cases come before the courts, they should have the same outcome. Remember the history video in Module 1? This is an idea that goes right back to the very start of the common law and those assize judges who rode out of London on circuit. Well, the fundamental rule of the doctrine of precedent is that a decision made by a higher court is binding on all the lower courts in the same hierarchy. So if the Queensland Supreme Court makes a decision about how to interpret a certain piece of legislation, well then the Queensland Magistrate Court must follow that decision. If the High Court of Australia makes a decision, then everyone has to follow it. The second reason is to do with appeals. I'm sure you've all generally heard of the idea of an appeal. If you think the court's got it wrong, you can take your case to a higher court and you can argue that the lower court got it wrong. So you appeal from the lower court to the higher court. But to do that, the courts need to be in a hierarchy. So let's look at those hierarchies. We'll start with the Commonwealth. The lowest level court in the Commonwealth is called the Federal Circuit Court. It's the engine room for a number of types of matters that are handled federally, most notably family law matters and immigration matters. It settles almost all of the divorces, almost all of the property separations, almost all of the parenting disputes for every state other than Western Australia, which has its own family court system. This is a very busy court, which, as its name suggests, sits in all the capital cities, but also regularly in regional centres around Australia. In some older texts or older decisions, you may see this court referred to as the Federal Magistrates Service or the Federal Magistrates Court, which were its previous names. Next highest is the Federal Court of Australia for most matters, or the Family Court of Australia for matters under the Family Law Act 1975. Some serious matters can start in the Federal Court or the Family Court, but very often those courts hear matters which are being appealed from the Federal Circuit Court. The Federal Court also hears appeals from tribunals, which are very similar to courts. We'll speak more about those in a few minutes. So what happens if you're still not happy? If you're not happy with the decision made by the Federal Court or the Family Court, can you appeal further? Why, yes, you can. Both of these courts also sit as what's called a full court, which means that instead of having a single judge decide the matter, you have more than one, normally 3. And we're still not done. If you've had your matter considered by the Federal Circuit Court and by the Federal Court or the Family Court and by the full bench of that court, well then the last stage is the High Court. You can't just appeal to the High Court though, there are 2 stages. First, you have to appear at a very short hearing, usually in front of one High Court judge, where you seek what's called special leave to appeal. At the special leave hearing, you have to show that your appeal is worth the court's time. That means showing that you have some prospect of success, and usually there's a significant issue that goes beyond just your case, a point of law that needs to be determined or clarified. If you're successful in obtaining leave to appeal, then you'll appear before the full High Court. Often, but not always, that means appearing before all 7 judges of the High Court, including the Chief Justice of Australia. If that's not enough to intimidate you, then you're either crazy or crazy brave. The High Court also has what's called original jurisdiction in relation to a number of matters set out in Section 75 of the Constitution, and also some matters conferred on it by legislation. We won't go too far into original jurisdiction quite now, but one example is that the High Court sits as the Court of Disputed Returns for the Commonwealth Parliament. So if there's a challenge to an election or a challenge to a person's eligibility for election, that challenge goes straight to the High Court. The most famous example is the quite recent case known as the Citizenship 7 case, in which 4 senators and 1 member of the House of Representatives, who also happened to be the Deputy Prime Minister, were tossed out of Parliament because they were dual citizens of Australia and some other country. The most important type of original jurisdiction for the High Court is its jurisdiction to hear constitutional matters, which are disputes about the Australian Constitution and especially challenges to Commonwealth legislation, where the states or somebody else argues that the Commonwealth has made laws in an area where the Commonwealth had no power to do so. Now remember, the hierarchy isn't just about appeals. Decisions of the High Court are binding on the Federal Court, the Family Court and the Federal Circuit Court. Decisions of the Family Court and the Federal Court are binding on the Federal Circuit Court. The higher the court, the stronger its decisions are in terms of establishing precedents. Now let's think about the states, because overall, the state courts actually handle way more matters than the federal courts. Each state has its own characteristics, and we'd be here all day if I tried to go through them all one by one. But there are a lot of similarities. At the bottom, each state and territory has what's called a magistrate's court or a local court. This is really the engine room of daily court activities. Often matters are dealt with very quickly, in just a few minutes each. Criminal matters and minor civil or administrative matters are all dealt with. The magistrates are incredibly hard working, and even though they move through their caseload quickly, their decisions often have huge significance for the people before the courts. Certainly in criminal matters, people can be sent to jail from the magistrate's court. And it will almost always be a magistrate deciding if a person who has been arrested should be released on bail or sent to prison to await their trial. Magistrates' courts also sometimes have other specialist courts. These are usually still magistrates, but sitting in a special capacity, for instance, in a specialist drugs court, or a specialist domestic violence court, or in a specialist coroner's court. The next step up from the Magistrates Court is called the District Court, or if you're in Victoria, the County Court. These courts deal with more serious matters, which are often referred to them by magistrates. They also deal with appeals from magistrates' decisions. This is the lowest level of court where you'll typically see jury trials for criminal matters. Now, if you're in Tasmania, the Northern Territory or the ACT, don't go looking for the District Court because those three jurisdictions are missing this level of court altogether. Next up from the District Court is the Supreme Court. The Supreme Court deals with a mix of things. First, it hears appeals from the District Court or from the Magistrate Court in those three jurisdictions that don't have a District Court. Second, it hears civil matters which involve a lot of money and criminal matters which potentially involve the harshest punishments. So that means the worst crimes. Third, there are a few matters which must be commenced in the Supreme Court, regardless of how much money is involved. For instance, when someone dies in Queensland, an application for probate to get their will moving has to be made in the Supreme Court. More importantly for you, when a person applies to become a legal practitioner, they apply to the Supreme Court to do so. The Supreme Court, much like the Federal Court, also has an appeal arm. Its name varies from state to state, but it'll be called the Court of Appeal, the Court of Criminal Appeal, or just the full court of the Supreme Court. As you might be able to guess, the role of these courts is to hear matters appealed from the Supreme Court. Can you appeal further? Yes, you can. The last stop is the High Court, which is not only the highest court for federal matters, but also for state and territory matters. And so the same process applies. First, you appeal and seek special leave, and if it's granted, then your appeal is argued before the High Court. As you might expect, the same sort of process works downwards for precedents. Decisions of the High Court bind all of the state and territory courts. Decisions of the Court of Appeal bind the Supreme Court and lower. Decisions of the Supreme Courts bind the districts and magistrates courts. Strangely, decisions of the District Court don't formally bind the magistrates courts in most cases, but it's very unlikely that a magistrates court is going to depart from a District Court decision without a very good reason to do so. The Commonwealth and all of the states have also established tribunals, which operate a lot like courts, but they're not actually courts. Instead, these tribunals are ways for the government to make administrative decisions rather than judicial decisions. In other words, they're like courts, but they use executive power rather than judicial power. These tribunals are also often used to resolve minor disputes in ways that are much less expensive and much less complicated than going to court. So, for instance, the Commonwealth has the Administrative Appeals Tribunal, and each state and territory has an equivalent. This is a tribunal that you can approach if a government agency has made a decision affecting you and you don't agree with that decision, or you think the decision has been made improperly or wrongly. Now, theoretically, the courts have always had the ability to deal with concerns of this type, but their powers have been somewhat limited, and going to court was so expensive that in many cases it just wasn't worthwhile. The idea of these tribunals is to make the process much more approachable. Some tribunals also include, as members of the tribunal, which is kind of the equivalent of judges, people who are not judges, not even lawyers, but who have relevant expertise in the specific area, for instance in building disputes. Generally speaking, the decisions of tribunals can be appealed to a court, usually the Federal Court for Commonwealth matters and either the District or Supreme Courts for state matters. Now I want to give a very brief overview of the court systems in the United Kingdom and the United States. To be honest, you won't really need to know this stuff, but you'll find from time to time that you'll have to read cases from the USA or the UK, and it can be really difficult to understand what you're reading unless you have at least a general idea of how those court systems work. Let's start with the United Kingdom. Now, the first thing to know is that while I'm talking about the UK, this hierarchy is actually the one found in England and Wales. Scotland has its own system. At the base of the system, we have the Magistrates Court, which in the UK, like in Australia, is the jumping off point for most criminal matters. They begin in the Magistrates Court, and more serious matters are referred upwards. At the next level, they have the Crown Court, which hears criminal cases, the County Court, which hears most civil cases, and the Family Court, which, as you might guess, hears family cases. Next up, we have the High Court. Beware here. The High Court in the UK is not equivalent to the High Court in Australia. It's closer to our Supreme Courts. It has the Queen's Bench Division, the Chancery Division, the Administrative Division, and the Family Division. This is the first of the courts that's really senior enough that you're likely to come across case law which will be considered persuasive in Australia. Next above that is the Court of Appeal, which has both a criminal and a civil division. It hears appeals from the High Court, but in criminal matters, it also often hears appeals directly from the Crown Court. The highest court of the lot in the UK is the Supreme Court, which used to be referred to as the House of Lords because the judges were in fact also lords sitting in the House of Lords. So tricky though it may be, you need to bear in mind that in the UK, like Australia, they have a Supreme Court and they have a High Court. But in Australia, the High Court outranks the Supreme Court, but in the UK, it's the other way around. Now, in the United States of America, like in Australia, there is both a state system and a federal system. And like in Australia, state cases can ultimately be appealed to the highest federal courts. However, since there are 50 states and therefore 50 state court systems, we're going to focus just on the federal courts. The basic level federal court in the USA is called the District Court, or the Federal District Court, to differentiate it from the state courts. The district courts handle both civil and criminal matters. The next level up is formally known as the United States Court of Appeal, but virtually everyone refers to them as the circuit courts. There's that history creeping in again as we think of those old assize judges riding on circuit around Britain. Now, the USA is divided into 12 circuits, and there's a Court of Appeal for each circuit. So New York City is in the Court of Appeal for the 2nd Circuit. Los Angeles is in the Court of Appeal for the 9th Circuit. New Orleans in the 5th Circuit. Miami in the 11th Circuit. Finally, at the top of the tree in the US is the US Supreme Court, which is a lot like our Australian High Court. Just like the High Court, the US Supreme Court is the ultimate court of appeal for the United States of America, and it also deals with questions arising directly in relation to the US Constitution, including the US Bill of Rights, which is part of the US Constitution. Again, however, don't worry too much about the details of the UK and the US systems. All I really need you to do is have a general sense that they have a hierarchy in the same way that we do, and perhaps have a sense of what are their highest courts and how they relate to one another. I'm here in the old Supreme Court chamber in Rockhampton, Queensland. This chamber was in use for more than 100 years and it's now heritage listed. It's no longer active as a courtroom, but it has all of the features that we'd expect to see in a modern courtroom. And you really should go and visit a courtroom near you from time to time during your studies of the law. Nothing really frames what you're learning quite as well as walking into court and seeing the issues genuinely being dealt with. So let's start at the very back. This area is called the gallery and it's where you'll sit if you come to court. In busy days with a list of matters, you'll also find lawyers and their clients sitting here in the back of court waiting for their matters to be called. Anyone can come and sit in the back of court because we have a system of open justice. The courts are only closed rarely and for good reasons. The only people who are really excluded from coming into court when there's a matter on are witnesses in the current case, because obviously we don't want those people having their evidence affected by hearing the case before they give that evidence. At the very opposite end of the courtroom to the gallery, we find the bench. The bench is almost always elevated, and this is where the judge sits. Their elevation places them in a position of command and control, and more practically, allows them to see everything that's happening inside the courtroom. In front of the judge, we find the judge's associate. The associate is like the assistant to a judge, but the associate has some key speaking roles. For instance, in a significant criminal case, it'll be the associate who reads out the indictment or the charges at the start of the case. Associates are usually recent law graduates, and one of the things that you should think about doing as you come to the end of your degree is consider whether you should apply for a 6 or 12-month stint as an associate to a federal court, a federal circuit court, a Supreme or District Court, or even a High Court judge. A stint as an associate will give you the opportunity to work with some of the most experienced and talented lawyers and judges in Australia. There's one other court officer to know, and they sit in different places in different courts, usually tucked out of the way inconspicuously. That person is the court bailiff. They have a range of roles related to the practical management of the courtroom. If someone's mumbling too loud in the gallery, it'll probably be the bailiff that asks them to stop it. In jury trials, the bailiff is the only person who's allowed to communicate privately with the jury, as the bailiff takes them to and from the jury room. If the jury needs anything, the bailiff is the one that they'll call. If equipment needs to be set up or managed in the course of the trial, the bailiff is the one who will make it happen. Facing the bench and the associate, we have the bar table. The bar table is where the barristers and solicitors who are participating in the trial sit in order to be heard. When a person becomes a barrister, we say that that person has been called to the bar, meaning that they have the right to sit at the bar table and to be heard by the court. Now, as the judge sees it, the participant furthest to the left represents the Crown in cases where the Crown is represented. Other than that, there's no set rule as to where people sit, but the custom is that the most senior lawyers sit closest to the right-hand side of the bar table. The next thing for us to do is look at the witness box. Now, this is a very old courtroom, so it has an elevated witness box with stairs leading up to it. Nowadays, witness boxes in more modern courtrooms are all fully accessible to anybody with a mobility disability. The most important thing about the witness box, though, is that the witness should be easily heard and easily seen by the judge, by the barristers, and by the jury. So what about the jury then? As you would probably know, in a criminal matter, there are 12 jurors. And in those few civil matters where they still use juries, there's usually a jury of 4. Quite often though, particularly in larger criminal trials, they actually select more than 12 jurors. They select the 12 jurors and a number of alternate jurors. So that if, for instance, a jury member falls sick or can no longer participate in the jury, they don't have to start again. They've got an alternate juror who can simply slot into the jury. Finally, there's one part of the courtroom you do not want to be, and that's called the dock. This is where the accused person sits during the trial, usually accompanied by a police escort. Now, of course, this is an older style of dock, and in more modern docks, the prisoner sits behind plexiglass and they have access to a microphone and a computer monitor so that they can see everything that's going on during their trial. Best thing to do, though, is avoid being in the dock at all costs. Now, not every courtroom will look just like this. For instance, courtrooms that are only used for civil matters don't usually have a dock, and courtrooms that are reserved for big cases may have more than one bar table. But generally speaking, if you go into court and you look around for the gallery, the bench, the associate, the bailiff, the witness stand, and in criminal courts, the jury bench and the dock, then you'll be able to orient yourself to pretty much any courtroom. Now, when you're visiting court, inevitably most of your focus will be on the courtroom itself. That's normal. But there's plenty to see and learn elsewhere in the building too. When you visit a court, here are a few things that I suggest you should identify. First up, the registry. This is where people come to file documents, in particular, documents that will need to be stamped by the court. Most civil actions begin with an application or a claim filed with the court, and that will be filed with the registry. Most of the time, visits to the registry for most firms will be done by paralegals rather than by lawyers. So it's a good idea to have a look in the registry yourself so that you'll know what goes on. If you do have to deal directly with the registry staff, remember that those staff have an immense capacity to help you out if the things you're filing are not quite right. Don't fall for the trap of assuming that the registry staff are just shop workers. Treat them like the professionals they are, and they can make your life a whole lot easier. Next, if you look around, you'll see a number of offices occupied by various organisations whose purpose is simply to help those appearing before the court. The most common of these is the duty lawyer. The duty lawyer is a solicitor or barrister paid by legal aid to give very short sessions of advice to people appearing before the court that day and who are representing themselves. It's quite common for a magistrate to stand a matter down, that is, put it off until later in the day, to make sure that a self-represented person has the opportunity to get some sort of legal advice, even if it's only a short session with the duty lawyer. Other organisations that you may find with offices there include the Aboriginal and Torres Strait Islander Legal Service, Legal Aid, sometimes men's advice services in domestic violence courts, and sometimes a court chaplain who has no legal role but whose role is to simply demonstrate compassion to people who are suffering, whether that's because they're a victim, whether they've just lost a matter, or whether they've just seen their child marched from the dock towards prison. Now, speaking of domestic violence courts, in courts that deal with a lot of domestic violence matters, there's often what's called a safe room. The safe room is a room that is available for women only. Not even male lawyers can go in there. Not even male police can go in there. The idea is to create a place of safety so that people who have come to court in fear don't find themselves in the waiting room sitting next to the person who's caused them that fear. Next, a lot of courts have what's called the practitioner's room. This is somewhere that you can only go if you're a solicitor or a barrister. It's a place where you can leave your bags and books, speak privately with the lawyers on the other side, and there's usually some joint resources in there like a computer, standard law texts, and a coffee machine, or at least a kettle. Similarly, the higher courts will have what's called a robing room, which is there to allow barristers to change into their robes and wig if they prefer not to wear them between their chambers and the court. Finally, you'll see dotted around the courthouse a number of small offices called interview rooms. These are places that you can meet with your client or your opponent to discuss matters privately. However, the custom, at least in Queensland, is first in, best dressed. If all the rooms are taken, well then you'll be meeting with your client out in the open areas. Now, if you're attending court as a visitor, you'll almost certainly see lawyers meeting their clients in these areas. And if you keep a sharp eye out, you'll probably also see lawyers negotiating with other lawyers. Please ensure that you give them enough space that it doesn't look like you're eavesdropping. That's considered to be particularly poor form. Okay, so I've been encouraging you to go and visit court, and so you should. A few things though about visiting court. First things first, courts publish online what's called the Daily Law List, or the Daily Courts List, or just the Daily List. It shows the parties, the type of action, the judge, the courtroom, and the time. That way you can find which court to go to and have some idea of what you're likely to see. Second, there are a couple of formalities to know. If you're in court before the proceedings begin, then when the judge is ready to enter, everyone will be asked to stand. The judge will come in and bow their head towards everyone. You should bow your head back. The court will then be formally opened by the bailiff, who will say something like this: "The Supreme Court of Queensland in its civil jurisdiction is now in session. All those having business before this honourable court come forward and give your attendance, and you shall be heard. God save the Queen." When the judge has sat down and the lawyers sit down, you're safe to sit down too. In recent years, there's been a minor controversy about whether religious people should be required to bow, because there's a concern that this may be a form of idolatry. let me reassure you it's no more than a way of showing respect for the court, the justice system and the Queen. It's certainly not acknowledging the superiority of the judge or any particular symbol or statue or icon. You might think of it almost like shaking hands, but at a distance. In any event, it will be considered most rude and disrespectful if you choose not to bow your head. If the court is in session and you enter or leave the courtroom, you should likewise face the judge and bow your head. Finally, you may find that the judge closes the court for all or part of a proceeding. You'll be able to tell when a court is closed because there will either be a sign outside the courtroom saying so or a light above the door saying closed court. You're also likely to find the courtroom itself is locked. This is often done when a vulnerable witness is giving evidence or where the nature of the evidence is such that the judge agrees to exclude the public. Some matters, such as domestic violence applications, are held in a closed court as a matter of routine. Honestly, do go along to court every chance you get. You'll learn 1,000 little things that you just can't learn in a classroom. So that's the court system in Australia. Next video, we're going to spend looking at the key products of the court system, judgments in the form of case law that can be used as precedents for later cases. In the second video, we'll look at how to research and reference case law, and then in the final video, we'll take an in-depth look at a single case report to learn how to read it effectively.